Hello, viewers. I hope that you're all doing well. This is Rishabh Bhandari, a graduate of National Law University, Lucknow. I am a legal researcher at Into Legal World, and as one of the faculties for this certification course on law of contracts, I'll be taking you through this journey. So, this course has been designed keeping in mind the needs of PCSJ aspirants, in that various judicial pronouncements and important provisions of law of contracts have been discussed thoroughly. At the same time, the previous year questions that have been asked in this examination are attached to each lecture under every topic as and when it arises, so that it gives you a holistic experience of the examination and makes you better equipped with the entire structure of the examination. So at the same time, I will also be attaching notes of the lecture at the end of each lecture so that it becomes easier for you to grasp the concepts and revise them exactly as you understand them. Now, as we all know, Indian Contract Act of 1872 is based on the English common law, and this Indian Contract Act of 1872 it is the one that guides the law of contracts in India. So in this video, as an introductory video to the certification course on law of contracts, I'll be talking about the essentials of a valid contract and also the types of contracts. Starting with the essentials of a valid contract, as we all know that a contract cannot be formed with just one person, and therefore it is necessary that there must be at least two or more parties to a contract. And thus, that is the very first essential for us, that there must be two or more parties between which a valid contract can be formed. Number two, offer and acceptance. As we all know that a proposal or an offer is the beginning of every contract. An offer, when accepted by the other party, which when communicates such acceptance to the first party, becomes an agreement which can then lead to a valid contract. Now over here we must understand that all agreements are not contracts. It is true that all contracts are agreement, but all agreements are not contracts. And the reason that I say that all agreements are not contracts is because in the process of becoming a contract, an agreement must be enforceable by law. So in simple words, if this is an agreement and this is a contract, then the gap which is bridged over here is by an element of enforceability. So that must be kept in mind, that for an agreement to become a contract, it must be enforceable by law. Now moving on to the third point, that is intention to create a legal relationship. Now this provision has not been mentioned in Indian Contract Act of 1872, yet it has been taken from the English common law in the famous case of Balfour versus Balfour, whereby it is noticed that every domestic relationship does not necessarily lead to a contract, because in our day-to-day life we notice many domestic relationships which would otherwise give away to a contract, but for the intention to create a legal relationship. Now since this is an introductory video, I would be sticking to pointers which I hope that you note down, but later as a part of this discussion of this certification course, I'll be talking about these judicial pronouncements and provisions thoroughly. So moving on, the fourth aspect, the fourth essential of a valid contract is free consent. This is a very important provision, since it is mentioned under section 13, and from section 13 to section 22, the entire provisions, they all deal with free consent. So is there a difference between consent and free consent? Yes, there surely is, because a consent becomes free when it is obtained without any coercion, undue influence, misrepresentation, fraud, and by mistake. If there is an agreement based on any of these five elements, then it cannot be a valid contract. Thus, it is important to keep it in mind that a free consent is void of all these five elements. So, moving on, coming to point number five, that is capacity to enter a contract. Now, when I say that a person must have the capacity to enter a contract, I'm talking about the Indian Contract Act, which specifically mentions that a minor or a person of an unsound mind or any person who is disqualified by law, these three categories, they do not have the capacity to enter a contract. Number six, lawful object and lawful consideration. So what do I exactly mean when I say lawful object? I mean the purpose of the agreement. If the very purpose of the agreement is unlawful, then naturally it cannot lead to a valid contract. To put it in an example, I go to a shop, I ask the person, the shopkeeper, that I want to purchase a gun, and when the shopkeeper asks me what do I need that gun for, what is the purpose for such agreement, then I tell him that I want to murder a person. Now, at this very instance, the moment the shopkeeper knows that this agreement is going to lead to something unlawful, that is murder of a person, then this contract would become void that very moment. It can never be a valid contract. At the same time, the consideration must be lawful as well. So if I go to the shop and I need that gun for my safety purposes, which is all lawful, but at the same time, in exchange of the gun, the shopkeeper does not want the money. Rather, what the shopkeeper wants is for me to kill a person with that gun. That is, the consideration for buying such a gun would be a death of a person. Then again, since the consideration becomes unlawful, so does the contract. Now, moving on. Point number 7 is the possibility of performance. If there is any person who gets into an agreement which is based on an impossible event, for example, I get into an agreement to sell my laptop for a certain price the day the world comes to an end. Now, this is impossible to be executed. So naturally, due to impossibility of performance, this cannot become a valid contract. Point number 8, consensus ad idem. Now, this is a very famous term that we get to hear every now and then, but when we talk about strictly from the realm of law of contracts, what we mean from consensus ad idem is that whenever there is an agreement, the subject matter of such agreement must be clear in the mind of both the parties. So if I go to a shop and I look at the shopkeeper, I see two apples. There are two kinds of apples placed at the table. I look at the A category of apple and I say, I want these apples because they are red and tasty. Give me the red and tasty ones. Now, it is really important over here that the shopkeeper also understands that I am only talking about the A kind of apple and not the B kind of apple, because red and tasty are very vague terms. So this is why it is an essential that the subject matter of agreement must be clear and the same in the mind of both the parties. Point number 9, any agreement, if it is expressly declared void by law, it cannot become a contract. There are many laws which exist today which ban, for example, betting. If any person engages in an activity of betting which is expressly banned by law, then of course it cannot be a valid contract. And lastly, the legal formalities, of course, that is the 10th essential. They differ from one case to another. In some cases, a contract must be a written one. At the same time, a contract can be an oral one as well. At the same time, there are cases where an agreement requires a contract to have the stamp, when in some cases without a stamp would do. So legal formalities, whenever they are applied, wherever they are applied, it becomes an essential for an agreement to become a valid contract. Now, having successfully discussed with you the essentials of a valid contract, I would be talking about the types of contract. Number 1, based on the mode of creation, and number 2, based on the type of performance. So on the mode of creation, there are express contracts, then there are implied contracts, then there are quasi contracts. So talking about express contract, they can be either written or oral. When I say that they can be written, I'm talking about the majority of the contracts that actually get dealt over. Obviously, the parties, they want codification of an agreement so as to have clarity, so as to later prove their the very agreement in case any dispute arises. Nonetheless, there is no law as such that bars any oral agreement to become a contract. So that covers the express kind of a contract. Now, what are the implied kind of a contract? To give you an example, I go to a bus station, I see a bus standing there. I naturally assume that sitting in the bus would get me to my destination, in return of which I would pay the conductor a certain price. The conductor never makes me an offer to get into the bus. I never accept his proposal, which he never makes in the first place. So it is an implied form of a contract. The moment I get into the bus and I sit and wait for my destination to arrive, I have an expectation that I am bound to pay for the fair price for the destination that I am to be taken. So that is an implied form of a contract for you. Now talking about quasi contracts. If you're aware of the term quasi, then by now you must have understood that these are pseudo contracts. And the reason why they're called quasi contracts or pseudo contracts is because they do not fulfill one of the essentials of a valid contract, that is the intention to create a legal relationship. So to put things in perspective, I'll give you an example. I pass by A's house and thinking that A's house is actually B's house. I end up delivering a bucket of rice to A's house, and this bucket of rice is one which was supposed to deliver to B's house or somebody else's house. It doesn't matter. So now A, seeing this bucket of rice and thinking that it belongs to him or that he deserves that bucket of rice or that it is meant for him, he picks up that bucket of rice, he consumes that bucket of rice, and now he is bound to pay for that bucket of rice. Now, is in this example, if you would notice, neither I wanted to get into a contract with A. That bucket of rice was meant for someone else. Nor A wanted to get that bucket of rice. That bucket of rice, he just took it. He never had the intention for paying for it. He mistakenly thought that it was meant for him and he took it. But now he is bound to pay for the bucket of rice now that he has consumed it. So there was no intention to create a legal relationship, and yet one has been formed. So this is why such examples, they cover the area of a quasi contract. Now that covers the first kind of contracts based on the creation. Now talking about the contracts based on the mode of performance. So in the mode of performance, they can be either unilateral or bilateral. Bilateral are very common contracts which we see in day-to-day lives. I go to a shop, I ask for a packet of Parle G, shopkeeper gives me the Parle G, I give him money. Both the parties are executing their part of the bargain. It's a valid contract, a bilateral one. But what is a unilateral form of a contract? A good example of a unilateral form of a contract would be when there is a lottery company which executes lottery tickets. And A, one of the parties who has bought the lottery ticket, gets the right selection and win the lottery money. And now when the lottery company gives that money to A, it is actually a unilateral form of a contract. Because if you think about it, the lottery company never mandated for A to buy the tickets. A is not bound by any condition to buy the ticket. He is not in any agreement with the company to purchase the tickets. And yet, if he does purchase the tickets, the company is obligated. The company is bound to pay A if he wins. So it is a unilateral form of a contract because only the company is bound to execute their part of the bargain. A has no foundation at all. So that sums up this introductory video for the certification course on law of contracts. I really hope to see you guys join the certification course. Thank you.